Welcome to my channel. My name is Melly. Thank you for being here tonight. Today is November the 5th. It is election day, so I am here back to cover more legal documents. Hi, welcome if you are new here. My name is Melly. Like I said, we cover all true crime, commentary, case trials, legal documents, deep dive presentations, body cam footage, etc. Pop culture, all of the above. And I appreciate you for being here. If you are returning, hi, thanks for coming back. Make sure you hit that like button, subscribe, help your girl out. I'm kind of newer on the creator end of things, so I do love true crime, but I do love reviewing legal documents as well. And for today, we have Jamel M. Demons filing a lawsuit against Broward County Sheriff's Office. If you are not familiar with who that is, he is a rapper by the name of YNW and MELLY. And he is incarcerated pending retrial, and he has now filed a lawsuit against the sheriff's office where he's being held for claims of inhumane treatment and cruel treatment. And so I'm going to play a video. It's like a 2-minute clip. So you can get familiar with what is going on, and then we are going to read the actual legal document, which consists of 12 pages. We read legal documents here on my channel all the time, so it's nothing new, hence why I wanted to try a pre-record rather than a go live. We'll get through this pretty quick. And so like I said, I'm going to play a 2-minute clip so you can familiarize yourself with the case, and we'll go from there. Thanks for being here. I appreciate it.
There's a new push to get rapper YNW Melly out of jail. He's currently awaiting retrial for the murder of 2 childhood friends, but a new lawsuit alleges he's being held in inhumane conditions. Local 10's 𝗟𝗵𝗃𝗲 live at the jail in Fort Lauderdale to explain this one. Andrew.
Yeah, we have it right here. This is a 12-page complaint. It's against BSO and the sheriff. Melly's family telling us they haven't spoken to him in years.
They're trying to break him down and get a result that they cannot get in the court system.
Attorney 𝗍𝗵𝗿𝗲 with the family at his side announcing a lawsuit filed asking a federal judge to order the immediate release of rapper YNW Melly.
I was not allowed to sit down with him the same as I've sat down with all of my clients over 30 years. I was not allowed to show him documents, to have a private conversation. I was put behind the glass where I had to yell for him to hear me.
He's been in jail since February 2019. The suit alleging his constitutional rights are being violated, restrictions interfering with his attorneys trying to help him, and debilitating isolation. He hasn't seen or spoken to his family in several years.
The last time I heard my son's voice on the phone was in 2022. Some days I don't know if he's alive in there. I don't know if something's happened to him in there.
The rapper, whose real name is Jamel Demons, is accused of murdering Chris Thomas and Anthony Williams' childhood friends. It was after a late-night recording session and allegedly made to look like a drive-by shooting. The first double murder trial ended last summer in a mistrial. The twists and turns that followed throughout included allegations of witness tampering, passing messages, and alleged plans to escape that were investigated. BSO only saying it does not generally comment on pending litigation. However, the jail does not utilize solitary confinement. Mr. Demons has been placed on administrative segregation, an alternate living assignment for someone who poses a serious threat. So what happens now is the federal judge is going to review all of this and decide whether or not the state has to answer for itself, basically, and explain why all these restrictions have been put in place. Meanwhile, that retrial, it has been set for September of next year. That's the latest here outside the...
Okay, so there you have it. You are now familiar with what is going on. He is claiming inhumane conditions where he is being incarcerated. I have the document pulled up here on the screen, filed on November the 2nd, 2024 by Jamel M. Demons against the Broward County Sheriff's Office. So it states, petition for a writ of habeas corpus. The petitioner, Jamel Demons, by and through the undersigned counsel, petitions this court for a writ of habeas corpus, asking the respondents to appear and show cause why Jamel Demons should not be immediately released from custody for egregious violations of the United States Constitution. In support thereof, the petitioner states the following. Introduction. The petitioner, J.Mel Demens, seeks his immediate release because he's being illegally detained under the conditions that violate the First, Fifth, Sixth, Eighth, and 14th Amendments to the United States Constitution. Demens is a Black male whose current detention conditions shock the conscience and could not even be imagined in this day and even in a third world country that has no guardrails protecting human decency and dignity. For over 3 years, petitioner J.Mel Demens has not been permitted to make a single phone call or have a single visit with his family or any member of the outside world, including not seeing or speaking to his own mother in over 3 years. Demens has and continues to be subjected to the type of debilitating isolation that renders his condition of incarceration cruel, unusual, and beyond belief in a civilized society governed by constitutional safeguards. He has also had restrictions placed by detention officials designed to impede his interactions with his attorneys and his ability to prepare for trial on capital murder charges. His cruel treatment by the Broward detention authorities warrants his immediate release from pretrial detention, since the detaining authorities have shown such a callous disregard for his human dignity right to counsel. Parties involved. Number 1, petitioner J.Mel M. Demens is currently incarcerated at Brown County Jail, where he is awaiting trial in case number etc. He has been in custody since his arrest in February of 2019. Number 2, respondent Sheriff Gregory Toney is a sheriff of Broward County and responsible for the humane treatment and overall conditions of inmates in the Broward County detention facilities that is operated by the Broward Sheriff's Office. Background. Petitioner was arrested on February 13, 2019 and has been in continuous custody since that date. He proceeded to jury trial, but the judge declared a mistrial in July 21st of 2023 when the jury was not able to convict him. In October of 2023, Broward Circuit Court Judge John Murphy granted the petitioner's motion to disqualify the state prosecutor in a motion contending the state attorney withheld evidence. A new set of prosecutors have come on and have done everything in their power to delay the trial from commencing. The case is currently stayed pending on a ruling and on appeal by the state attorney. Meanwhile, the plaintiff, who remains in custody since February of 2019, is continuously abused and denied bond. The petitioner has not been permitted phone or in-person or any type of visitation with his family, including his mother, for over 3 years. In addition, the respondents have placed unreasonable restrictions and interfered with the ability of his attorneys to interact with him. This has included forcing attorneys to wait for hours to see him, not letting them see him at all, and forcing them to meet him in conditions that interfere with and impede the privacy and privileged nature of his communication with his lawyers. On and around April 11th, 2022, inmate Jamal Myers filed a grievance report in retaliation of the plaintiff's refusal to purchase him food from commissary. Inmate Myers filed a grievance report against not only plaintiff, but another inmate. Inmate Myers alleged in part that Mr. Demens was planning an escape by having his attorney bring in 2 handcuff keys to aid in the escape. In response, correction personnel conducted a shakedown of plaintiff's cell and another inmate cell. In accordance with certain supplemental investigation report, the shakedown of the plaintiff's cell unearthed commissary and excessive jail-issued clothes, which were confiscated and disposed of per operational orders of the jail. However, the other inmate on the dorm was found in possession of shanks, prescription drugs, and other contraband. The inmate was subsequently charged for his possession of contraband. Plaintiff was found to have committed no wrongdoing, and the investigation closed as to the plaintiff on April 11th, 2022. Despite no wrongdoing, the plaintiff was moved from his current dorm into solitary confinement, and all phone communication with the outside world ceased. Shortly thereafter, two of the plaintiff's defense counsel attempted to visit him and were not allowed entry into the jail facilities. The facility refused to provide any reason as to the denial. The following day, attorney Stuart Adelstein made an oral tennis motion regarding the jail's interference with the plaintiff's right to counsel. Honorable Judge Andrew Siegel summoned Brown Sheriff's Office attorney Christian 𝐁𝐮𝐲 to court. Attorney 𝐁𝐮𝐲 defended the actions of the facility, that there was an open investigation against Mr. Demmons, and further that he was a threat to the security of the jail because he was alleged by attorney 𝐁𝐮𝐲 to have been found with a shank in his dorm. My apologies if I am not pronouncing that right. Attorney Adelstein inquired if any of Mr. Demmons' defense team were at that time or ever under investigation, and attorney 𝐁𝐮𝐲 responded no. Judge Andrew Siegel instructed attorney 𝐁𝐮𝐲 that the jail could not restrict the plaintiff's contact with his attorney, and attorney 𝐁𝐮𝐲 would have to come up with and effectuate plaintiff visits with his attorney. As a result, plaintiff's visitation took place in a visitation booth located downstairs in the bond room. The visitation booth did not accommodate Mr. Demmons and his defense team in one sitting. Moreover, it was impossible to review any documentation with Mr. Demmons due to the plexiglass divider. Not only was the visitation room not large enough to accommodate defendants' attorneys, but anyone standing outside of the room could hear everything that is said in the room, violating defendants' right to private and privileged communications. On September 7th, 2022, attorney 𝗵𝗿 filed a motion to remove visitation, communication, or interaction restrictions. Prior to the hearing on the motion, attorney 𝗵𝗿 contacted Christian 𝐁𝐮𝐲 in an effort to reach a resolution without hearing. Instead, 𝗵𝗿 was met with unhinged screaming from the BSO attorney, questioning her about, "What do you talk about? Why do you spend so much time with him?" Christian 𝐁𝐮𝐲 ended the conversation in telling attorney 𝗵𝗿 that if she went forward with the hearing, he would, quote unquote, embarrass her. It is important to note that the plaintiff defense team was not in possession of the incident report, so the defense team and the court all relied on Mr. 𝐁𝐮𝐲's proffers to the court that have not been determined to be untruthful. Despite the believable threat of character assassination, 𝗵𝗿 proceeded to hearing on the motion. Christian 𝐁𝐮𝐲 ranted and raved about unverified allegations and the behavior of the plaintiff. Despite Christian's attempts to not only embarrass attorney 𝗵𝗿, he failed. 𝐁𝐮𝐲 was instructed to accommodate visitation between plaintiff and his attorney that was free of third parties being able to listen. On September 29th, 2022, 𝗵𝗿 was contacted by a reporter for an online media outlet that informed that an unknown member of the BSO contacted them and led them to believe she was an attorney that inmate Myers was speaking to about in his unfounded grievance. As a result of the accusations of the Broward Sheriff's Office, stories ran for weeks about the alleged nefarious escape plan between 𝗵𝗿 and the plaintiff. The escape plan was created by the Broward Sheriff's Office, was not the worst of it. On December 1st, 2022, under the charge of the Captain Hubert, plaintiff without cause was moved to a unit inside the jail that is meant to accommodate 24 inmates. Plaintiff was the only housed on the vacant unit with no privileges, no television, and no access to newspaper. When plaintiff was allowed his hour out of the cell, all other inmates had to go back inside their cells. Specifically, during December of 2022, Lieutenant Baptist, along with Sergeant Anthony Kidd, threatened plaintiff if he told his attorneys about his treatment that they would, quote unquote, hide him away from the world. Plaintiff has not had phone privileges since May 8th of 2022. The plaintiff has not had private visitations with his defense team since March of 2022. As recently, without reason, plaintiff was moved to the Paul Reen Detention Center and has housed on the floor with no one else. His door has been removed from the cell, preventing any privacy, and he had a member of the emergency response team shadowing him 24 hours a day. They were instructed not to speak to him. Plaintiff went without any human contact for several months until again Broward Sheriff's Office moved him. Florida Statute 901.24 states that a person arrested shall be allowed to consult with any attorney entitled to practice in the state alone and in private at the place of custody as often and for such period of time as reasonable. The ongoing denial of Mr. Demmons' access to his attorney is not only preventing Mr. Demmons' attorneys from properly preparing Mr. Demmons' defense, but is in violation of not his only Sixth Amendment rights, but Florida law as well. In order to punish and isolate Demens, the respondents have isolated him and not permitted a single phone call or visit from the family in over 3 years. The isolation has inflicted enormous emotional impact on him and is designed to deteriorate his mental health and his ability to prepare for a trial that is now scheduled in September of 2025. These restrictions are not for security reasons and bear no rational relationship to any legitimate security interest. The respondents monitor the custody of thousands of inmates and have never imposed such restrictions. No non-Black inmates currently have any such punitive restrictions. Grounds for petition. Ground 1. The respondent has illegally and improperly violated petitioner's constitutional guaranteed right to counsel and his ability to prepare for trial. These actions have been done with no due process and bearing no relationship to any legitimate state interest. Thus, he is being illegally detained in violation of the Constitution of the United States. Ground 2. The respondent is being illegally detained under conditions that are cruel and unusual and that not only bear no rational relationship to any legitimate state interest, but violate the petitioner's rights to due process and equal protection. On September 7th of 2022 and other dates, petitioner has continuously sought relief in state court, which relief has been useless. Bringing these constitutional deprivations to the attention of the state court and state authorities has not provided any relief. Prison walls do not form a barrier separating prison inmates from the protection of the Constitution. Hence, for example, prisoners retain the constitutional right to petition the government for redress of grievances. For instance, they are protected against invidious racial discrimination, and they enjoy the protection of due process. Under the U.S. Supreme Court's holding in Proconir versus Martinez, regulations, conditions, and restrictions on jail inmates could be justified only if it furthers an important or substantial governmental interest unrelated to the suppression of expression, and the limitation is no greater than the necessary or essential to protect the interest. Because prisoners retain these rights. When a prisoner, regulation, or practice offends a fundamental constitutional guarantee, federal courts will discharge the duty to protect constitutional rights. For instance, correspondence regulations are unnecessarily broad, the court concluded, because prison officials could effectively cope with the security problems raised by inmate-to-inmate correspondence through less restrictive means, such as scanning the mail of potentially troublesome inmates. The district courts have also held that correspondence regulation has been applied in arbitrary and a capricious manner. Prison walls do not form a barrier separating prison inmates from the protections of the Constitution. Hence, for example, prisoners retain the constitutional right to petition the government for redress of grievances. The Court of Appeals held that the district court properly used strict scrutiny in evaluating the constitutionality of the Missouri correspondence and marriage regulations. Under Proconir versus Martinez, the correspondence regulation could be justified only if it furthers an important or substantial governmental interest related to the suppression of expression, and limitation is no greater than necessary or essential to protect that interest. Because prisoners retain these rights, quote unquote, when a prisoner, regulation, or practice offends a fundamental constitutional guarantee, federal courts will discharge their duty to protect constitutional rights. Several factors are relevant in determining the reasonableness of challenged prison regulations. First, there must be a valid, rational connection between the prison regulation and the legitimate governmental interest put forward to justify it. A second factor relevant in determining the reasonableness of prison restriction is whether there are alternative means of exercising the right to remain open to prison inmates. A third consideration is the impact of accommodation of the asserted constitutional right will have on guards and other inmates, and on the allocation of prison resources generally. Finally, the absence of ready alternatives is evidence of the reasonableness of a prison regulation. The respondent's outrageous interference in the petitioner's right to counsel and his ability to prepare his legal defense violates the United States Constitution. Likewise, the respondent's isolation of the petitioner and refusal to permit him to have contact with the outside world, including his mother and family for years, is inhumane and patently unconstitutional. Request for relief. Wherefore, petitioner respectfully requests that this court issue a writ of habeas corpus directing respondents to show cause why he should not be released from unlawful detention and grant such other relief as the court deems just and proper, because of the abusive and outrageous violations of the rights guaranteed by the United States Constitution, coupled with the efforts by the state to delay his trial after years of custody. It is requested that his honorable court order the petitioner's immediate release from custody. Respectfully submitted by 𝗵𝗂𝗶𝗶𝗲, which is his attorney, on November the 2nd of 2024. So there you have it, the lawsuit from YNW MELLY to the sheriff's department, where he is incarcerated for inhumane conditions. So we just covered that document, and you are not familiar with the case. So thank you for stopping by, and make sure you like and subscribe, and make sure you support your girl, please. I would really appreciate that. And I usually do lives mostly. I'm working on some pre-records, so I will hope to see you either on the next pre-recorded video or on the next live. Make sure you hit that like button. Bye.